Hey everyone, welcome back to the Wealth Planning 101 video series. I'm McKenna Law.
And I'm Ian McGraw. So far, we've provided an overview of savings and investments, introduced you to various types of credit, informed you about some basic tax concepts, and highlighted several benefits of charitable giving.
Today, we're excited to share insights on estate planning, something we believe is an essential part of financial planning. Many people think estate planning is only necessary when your hair turns gray. However, estate planning can benefit everyone, regardless of how much you have in the bank and how many booster seats are in your car.
Absolutely. For young adults, understanding the basics of estate planning can offer a strong foundation for financial responsibility, helping them feel more in control of their future. Today, we'll cover why we believe estate planning is important, some key components involved, and some practical steps that you can take to help protect you and your family's legacy.
Our goal today is to make estate planning as straightforward and practical as possible. We'll break it down into three essential components: how assets transfer, what key documents to have, and the specific people to appoint for each role in an estate plan. These components are intended to comprise a coordinated estate plan, protecting assets and loved ones.
Throughout this presentation, we'll emphasize some actionable steps, practical examples, and considerations that can help young adults see how estate planning can be a meaningful part of their financial journey. Let's start with the first key area: how assets transfer after someone passes. Understanding this part can make all the difference in achieving a seamless wealth transition.
When someone passes away, their assets can transfer through five main avenues: by title, beneficiary designation, probate, will, or trust. Each method has distinct implications on how efficiently and quickly beneficiaries receive the assets, which makes understanding these avenues essential.
Let's look at a couple of examples. For instance, an asset held in joint tenants with rights of survivorship will automatically transfer to the surviving owner, bypassing the lengthy and often costly probate process. On the other hand, assets without such arrangements generally go through probate, which means the courts oversee the distribution, a process that can take sometimes months or even years.
Titling refers to the way assets are legally owned. How an asset is titled can determine who inherits it, whether it avoids probate, and even whether it offers certain protections from creditors. For example, an individually titled account goes through the owner's will if one exists, which a jointly titled account will pass directly to the surviving owner, avoiding probate altogether.
Correct. This is especially relevant for young adults with joint bank accounts or jointly owned property. Understanding titling can help prevent unintended outcomes like assets automatically transferring to a co-owner, and can help streamline their estate plan by avoiding unnecessary probate procedures. It's an essential consideration for anyone starting to build wealth.
Let's briefly discuss some other common forms of titling. Tenants in common is a form of ownership where two or more individuals own an account or property, but their shares don't have to be equal. For example, two people might own a piece of property with one owning 20% and the other owning 80%. What makes tenants in common unique is that one owner's share is distributed according to their will when that owner passes away. This means that the portion of the property owned by the deceased will go through probate as directed by their will.
Now, payable on death or POD accounts and transfer on death or TOD accounts allow you to designate a beneficiary who will automatically receive the account's assets upon your death, avoiding probate. Trusts and LLCs are legal entities that own and manage properties and accounts. The person who sets up the trust or LLC decides how the assets will be distributed. Assets owned by a trust or LLC generally avoid probate, which makes them a more streamlined way to transfer wealth or manage property.
Beneficiary designations are another way to bypass probate. They're used on retirement accounts, such as your IRA or your 401k, life insurance policies, and transfer on death or payable on death accounts. These designations specify who receives the assets directly, regardless of what's stated in the will.
We recommend that young adults review these regularly, especially after major life changes like a new job, marriage, or childbirth. An outdated beneficiary designation could inadvertently leave assets to someone no longer intended. Reviewing beneficiary designations on accounts every few years or in the event of major life changes can help ensure that your beneficiary designations align with current intentions, providing more control and peace of mind.
Probate is the legal process of validating a will and overseeing the distribution of assets that don't automatically transfer by title or beneficiary designation. While probate usually ensures a decedent's wishes are followed, it can be costly and time-consuming, sometimes taking months or even years to conclude, depending on the state you reside in.
Many people want to avoid probate to reduce costs and expedite asset distribution. One way to do this is by designating beneficiaries or setting up certain types of trusts, which we'll cover later. It's helpful for young adults to know how to avoid probate on key assets, making it simpler for their loved ones if something unexpected happens.
As mentioned, the probate process varies depending on the state. It can take 9 months to 3 years, and the cost can add up quickly. You might be thinking, I don't have a lot of assets right now, so what happens if I die without a will? If you pass away without a will, it's called dying intestate, which means that the laws of your state will determine how the property is distributed.
Any asset not passed by title or beneficiary designation will be distributed according to the state's heirs at law rule. These rules vary, but generally, if you die without a will, your assets will first go to your spouse and children. If you're unmarried, you don't have children, your assets will go to your surviving parents. If your parents have predeceased you, the assets will be distributed to your siblings, and so on and so on. This can be a complicated process, which is why having a will in place helps ensure that your assets go to the people as you wish.
Next, we'll discuss the essential documents in a comprehensive estate plan: the will, various types of trusts, power of attorney, and healthcare directives. Each document serves a unique purpose, and together they create a plan that honors an individual's wishes while providing for loved ones.
For young adults, setting up even basic versions of these documents can offer significant clarity, direction, and protection. Knowing about these documents can help you decide whether you need a simple will or if a trust might be more appropriate as you accumulate more assets or are in certain life stages.
A last will and testament is often the foundation of an estate plan. It's a legal document that details how someone's assets should be distributed and names guardians for minor children. It's worth noting that a will only applies to assets titled in the deceased name alone.
Yes, and it's important to update the will as life changes. This means if you get married, get divorced, have a child, or acquire significant assets, you should review your will to ensure it reflects your current wishes. Without a will, state law determines asset distribution, which might not align with your personal wishes.
We'll go into more detail about key people involved in an estate plan later, but for now, let's briefly cover who you would typically name in the will. First, there's the executor. This is the person who's responsible for carrying out the instructions in your will and overseeing the distribution of your estate according to your wishes. Next are the beneficiaries, the people or entities like a charity that will receive assets from your estate.
If you have minor children, you'll also name a guardian. This is the person who will care for your children if both parents pass away. Lastly, if your will creates a trust, you'll appoint a trustee. The trustee manages and administers any trusts set up by your will. These key individuals will help handle your estate according to your wishes.
There are also a few key provisions in a will that are important to understand. The first is specific bequests. These are property distributions, real estate distributions, or gifts that you want to leave to individuals or charities. For example, if your alma mater is really important to you and you want to ensure that they receive a donation upon your passing, you can include a specific bequest in your will to leave them a certain sum of money.
Another key provision is the residual estate. This refers to everything left over after all the specific bequests have been made. The residual estate can be distributed however you choose, but it's often distributed in one of two ways. The first is simple, it's outright to the beneficiaries, meaning they'll receive it after the executor has administered the will. The second is that you can set up a trust through your will, which allows you to control when and how the assets will be distributed to your beneficiaries. This can be useful for guiding the long-term management of your estate. It's important to think through who your beneficiaries are. For example, how old they are, they have a history of issues with managing money. This can help determine the need for a trust or not, based off if you want them to have access to the assets immediately or not.
Trusts provide additional control and help avoid probate altogether. A trust can hold assets and specify the conditions under which they're distributed to beneficiaries, offering more privacy and flexibility than a will.
Trusts are constructed for young adults wanting to control how and when beneficiaries receive their inheritance, such as holding assets until a beneficiary reaches a certain age. For those starting to accumulate significant assets, especially if they're concerned about creditors or ensuring privacy and asset distribution, trusts offer significant legal protections.
Let's dive into some trust specifics. Trust can be created during your lifetime or through your will after you pass away. There are many different types of trusts, but they usually fall into two main categories: revocable trusts and irrevocable trusts.
A revocable trust is flexible. It's set up during your life and you can change it whenever you want. This includes changing trustees, beneficiaries, or how assets are distributed. It's a great option if you want to stay in control throughout your life. In contrast, an irrevocable trust is much more permanent. Once it's created, the terms are set and you can't easily make changes. It's ideal when you want to lock things in and ensure that assets are protected for the beneficiaries.
Now let's talk about the key roles within a trust. The grantor is the person who creates and funds the trust. The beneficiaries are those who receive distributions from it. Then there's the trustee, who manages the trusts, handles the distributions, and helps ensure everything runs smoothly, like paying taxes or managing assets.
And finally, there's the trust protector, who serves as a safeguard. They have the authority to step in and make sure the trustee is doing their job correctly and in the best interest of the beneficiaries. Together, these roles help make certain the trust operates as intended, whether it's set up for use during your lifetime or to protect your assets after you pass away.
A power of attorney, or POA, is a document that becomes especially important if someone becomes incapacitated. It allows a designated person, known as an attorney in fact, to manage finances, pay bills, and handle important financial decisions. It's essential to establish a POA well before incapacitation, ensuring that your affairs are in trusted hands if you are ever unable to manage them yourselves. Choosing a reliable and financially savvy person for this role is crucial, as they'll have significant authority over your financial matters.
There are a few types of POAs to consider, especially when determining when the power takes effect. A durable POA becomes valid as soon as it's signed, meaning the attorney, in fact, can act on your behalf immediately, even if you're fully capable. A springing POA, on the other hand, only comes into effect after a significant event, like being declared incapacitated by a physician. Selecting the right person should align with your values and priorities, as this helps avoid financial chaos in unexpected circumstances, something that's invaluable at any age. Remember, though, a POA is void upon death. Once that happens, the executor steps in to handle financial matters.
An advanced directive for healthcare is also known as a living will. It outlines healthcare wishes and designates a healthcare agent who can help make medical decisions if someone cannot do so for themselves. This document can be especially important in emergencies to help ensure your medical care aligns with your personal wishes.
It's important to note that healthcare directives address various aspects of your medical treatment. For example, it specifies how long you want to remain unconscious if a doctor determines you're in a state of permanent unconsciousness. While it can be uncomfortable to discuss these matters, having clarity in a healthcare directive can significantly help your loved ones understand your wishes. Additionally, it outlines your preferences regarding life-sustaining measures, whether you want all measures taken, minimal interventions, or specific treatments. The directive can also specify your wishes regarding the disposition of your body, including whether you would like to have an autopsy performed or if you wish to donate your organs. Many states have standardized forms for advanced directives, and some combine the living will with a healthcare power of attorney. Healthcare decisions can be emotional and stressful, especially during critical times. But having an advanced directive and a trusted healthcare agent in place allows family members to feel confident that their loved ones' wishes are honored, providing peace of mind for both the individual and their loved ones.
Now, let's discuss the key roles that make an estate plan work: executors, trustees, guardians, and agents for healthcare and finances. Each individual plays a crucial role in carrying out specific aspects of an estate plan, and choosing the right person for each role is essential.
The executor is responsible for administering your will. This person will work to ensure that any remaining bills are paid, your final income tax returns are filed, and your assets are distributed properly to the beneficiaries according to your wishes. An executor can be an individual, a group of individuals, or even a corporate entity.
Next, we have the guardian, who's the individual designated to care for minor children if both parents pass away. This role can be filled by a person or a couple that you trust and love. Additionally, there's the trustee, who administers any trust that you've created, whether during your life or through your will at your death. They will ensure distributions to beneficiaries are made according to the trust agreement and are responsible for filing any trust tax returns.
Beneficiaries are the individuals or organizations named to receive your assets, whether through your will or trust. This can include family members, charities, or other organizations. Now let's quickly touch on the power of attorney and healthcare agent. A power of attorney helps manage your finances should you become incapacitated, while the healthcare agent will help make medical decisions on your behalf if you're unable to do so.
We encourage you to think through successors for each of these key roles as well. If you have someone you trust in each of these positions, consider who would be the backup to that person if something were to happen to them.
For young adults, selecting trustworthy individuals who share your values and are reliable can be crucial. These decisions help ensure that your estate plan is properly executed and that your wishes are honored.
To wrap things up, let's talk about some practical steps to start estate planning. First, start by making a list of assets and any beneficiaries that you'd like to designate. From there, you can meet with an advisor to discuss which estate planning tools fit your needs best.
Remember, estate planning is a process. Regular reviews every 3 to 5 years or after major changes help ensure the plan stays aligned with current goals and intentions. Starting early can give young adults peace of mind and a strong foundation for a secure financial future.
Thank you all for joining us. We hope we've given you some tools to discuss estate planning with your loved ones and to start designing an estate plan of your own.
This concludes our Wealth Planning 101 video series. We've enjoyed sharing our insights and tips to help empower you on your journey to net worthwhile. We encourage you to apply the knowledge to your own financial strategy, and we're here to answer any questions you may have.